right, let's bring in our guests for this hour. Joining us to discuss, criminal defense attorneys Jacqueline Goodman and David Bruno. Great to see you guys. Thank you so much for joining me on the program. And David, I'll begin with you. You heard the judge right there, basically denying the defense's motion to dismiss. And she said very clearly that at the very least, this defendant has admitted giving the water bottle with the tetrahydrozoline to this victim. That, to me, is basically murder. There's no assisted suicide exceptions in the law as far as murder is concerned. But I think the area where the defense is going to have to really fight very hard on their case is this idea that maybe tetrahydrozoline wasn't a substantial factor in her death. To me, that's the only path to acquittal for them. Do you agree?
I do. That was probably the strongest area of cross-examination for the defense attorney on the toxicologist, when they were able to bring out the medications and other drugs in the system that could have had adverse effects or contributed or led to death. Absolutely. I mean, what we didn't hear in the judge's decision, and that is giving the state all the benefits, all the inferences, all the reasonable inferences, is that she had all the motive to do what she did, right? Because of the theft, because of the fraud, and then actions that she showed, the deletion of the text messages, some of the search history. I mean, there's a lot of different things that push the jury into this category of guilt, in my opinion. And the causation issue is probably their best shot at arguing that there's other things that contributed or caused the death.
Jacqueline, I've always contended that perhaps there was some room to work with the motive, because there were signs that this woman really wanted to be generous to this young lady. Now, she might have taken it to a level far beyond where Lynn Hernan, or the victim in this case, would have wanted it to go. But it was certainly clear that this was a woman that was struggling in life, had some problems, maybe even was suicidal. Maybe we'll get some more information about that in the defense's case. But the motive always seemed a bit flimsy for me, in terms of the fact that this defendant was on her bank account, so she was comfortable doing that. This defendant was on her safety deposit box. She was in her will. I mean, there was clearly a relationship, a good one, between these two. It's a shame that if she was just trying to help this woman, do whatever it is she wanted to do, she still could very easily be found guilty of murder. All right, let's turn now to the case of the Kowalski family against Johns Hopkins All Children's Hospital. David, you heard closing arguments today. I thought both parties argued their cases very well. As I look at the case, I think the biggest problem for the hospital is not so much the actual factual stuff in terms of the way they treated Maya as far as medically treating her. I think they're on solid ground with standard of care, things of that nature. But it was her treatment of her as a person and the family's treatment that could cause problems for them.
Yeah, sure. I mean, we've been on the same page the last couple of weeks on this, is the demeanor of the witnesses, the way that they came across. That is a huge issue when the jury is watching the witnesses and making assessments of credibility, especially when there's two stark narratives here. Let's not forget, I mean, the defendants are coming out and blaming the mother, and the plaintiff is blaming the hospital, and the jury's going to have to make a decision here. And one of the things that's going to cut against the defendants here is the demeanor and the attitudes and the way that they've presented their case in the courtroom when there's such a credibility decision to be had.
Yeah, and this family, the way they phrased it, I think doctors blew up this family.